came upon. It was your wise counsel so that all of us could have work to do, and I took it in good faith. Remember, my first letter to you indicated I'm well trained and experienced to carry out my responsibility as the accounting officer. Kindly return my roles to me. 4. Peace, tranquility, and harmony at workplace will enable deliver to our employer. Let us create a harmonious working environment. And 5. The county assembly or any organization cannot have 2 chief executive officers. This has divided the staff right in the middle, and this has divided the staff right in the middle. The workforce has lost direction. I had promised to create a staff workforce that could support the honorable members in delivering their mandates. This has happened in the past, and it can happen now. I have the requisite experience in administration and leadership. Kindly let us use the organogram effectively, and there is a clear chain of command. Thank you. Yours sincerely, signed, Daniel Orina, Clerk, County Assembly of NYAMIRA. CC, Director, Human Resource. Yes. Yes.
On page 5, I believe there was an amendment made of the plan. In the last paragraph, the same was signed and after
I don't have the same. Is it partly an amendment or a withdrawal? Because if it is an amendment, you can't amend just a paragraph, then you bring a piece of the paper. So I'm not aware unless I ask if it was received. I don't know when it came and if it came beyond the days given.
Excuse me, sir. I think I want to clarify that within a few minutes I realized that mistake on one sentence.
You can answer seated kindly.
I realized the word that missed within one sentence. I called the officer in the speaker's office, one next to Nomari, and informed him that I'm making a change on that sentence. But he had left office. I did the amendment, and immediately I sent it to him. He told me he would receive it and put it in my file. Excuse me.
Order. Yes, continue.
I want your protection, Chairman.
Okay.
The Nixon Nomari can testify that I gave him in a few minutes time that information where I done the correction. At the same time, I sent to the chair of the service board.
Okay.
And indicating that I've done the correction.
That is noted. That is
the
noted.
The chairman approved it. He said I've received it.
That is noted because we are on record and it is going to be captured and answered. The correction can be noted. However, you should have done the whole document afresh and withdrawn the other one and bring this one for filing, not a section. Thank you for that. And now, before we start the part of defense, we would have to do an oath of truthfulness, and our legal counsel here will preside over that. And kindly, if after we have done the oath, you will now give us the right statement that we need to amend to in this response. Okay, thank you. Sorry, we were doing some bit of consultation. And before we handle this matter by matter, when it reaches the time for our client, now in this board, the Honorable Clerk, to give his remarks, we'll give him an oath to that effect. I wanted us to have a small opening remark from you, Wakili. Then I can now go matter by matter as evidenced by the board, so that now we can proceed.
Thank you, Chair. First of all, I'd like to confirm from yourself whether with you have a copy of our letter dated the 1st of July 2024, addressed to the official email address of the chairman of the board from the firm of Newly and Company Advocates. I don't know whether the same is in your record. The same was sent out on the 1st of July. So we would like to rely on that letter fully.
Yes, we received a letter. However, we wish to note that we don't know the person in that letter. If you read it carefully, so today, sitting from here from my ruling, we will have to dismiss that letter as part of this process. If you look at it carefully, I will read it, and so that we can be on the same page. That's why we never mentioned it. And still, as part of the process, I think the chair furnished me with everything that you sent him. It is a reading letter to the Speaker. The chairperson, NYAMIRA County Assembly Service Board, County Assembly Buildings, and this letter is coming from Gwele and Company Advocates and Commissioners of Court. Reference, dear sir, reference is disciplinary hearing of Mr. Daniel Oginda Orina, Clerk of Kiambu County Assembly. So as a result of that, we won't withdraw a letter that is written from a law firm. We will have to work without it in this fair hearing.
Well, Derek, but I'd also like to point you to Article 159 of the Constitution that talks about technicalities. And by virtue that the only error on this letter is the address regarding Kiambu County Assembly, we'd like you to take note that we would rely upon Article 159 of the Constitution fully. Yes. Secondly, we'd like to express our reservations regarding proceeding with this hearing for reasons that we have not been supplied with your evidentiary material that you may have, or witness statements regarding persons who are alleged to have particularly been involved regarding allegation number 1. Yeah, we have not been supplied material. Again, we'd like to rely upon Article 47 of the Constitution fully, as well as the Fair Administrative Act. Thirdly, we have reservations regarding 2 members of this board who are sitting here today. We are fully relying upon the principle of sub judice for reasons that they were discussing this matter yesterday at Royal Media Services, and aired their express opinion, which in our opinion is biased towards our client, and you can take that on record as well. And lastly, we have noted the absence of the chairman in the board. We have indicated that we have a letter from him indicating that he will not be sitting for a number of reasons. We have not been furnished with that letter. We will be requesting for the same. And for reasons that the board is not properly constituted by the absence of the speaker, we would be having our reservations. Please take that also on record.
Thank you, Wakili. And we would like to also note that this is a fair hearing. It's not a court process. We are not here to make a judgment. We are here to hear what the client has to say and defend ourselves as the board as per the allegations. That is the purpose of this hearing. All the rest can be challenged after the board decision. What we did in our standing orders, and even in accordance with the law, fair hearing is part of any process of accusation. So when we came here, one, you should realize that the chairman of the board, our board is constituted by quorum, not by the presence of the chairman. And in the absence of the chairman, we have a vice chairman who takes center stage. And that is one well noted. Number two, in the response to the show cause letter, your client indicated so much. He was talking about you, the chairman, you. And yet the letter was addressed to the County Assembly Service Board chairperson. So it was a bit personal, and we had to relieve him of that, so that is not part of this process, because it becomes personal when now we are addressing the issue. Then, if the letter hearing that you're saying came from your end had this omission, then when we received it, we simply redirected it to Kiambu County. That is what we could have done. And if you realize this in time, you would have serviced us with the letter in time, so that as we talk here, we cannot talk about a letter that we cannot recognize up to this point. Finally, Wakili, to bring you two up to speed, is that in a show cause letter, we have given him the accusations. It's either he knows about them or not. So once he denies, in this fair hearing, we have the right to express ourselves, and he expresses himself. Finally, you talked of reservations of 2 members who did this on air. You should also take note that part of our evidence are the claims by our client that he did in the offices that were released to the media. And as we talk here, this board is tainted an image of corrupt people and an image of bad people, which we have to demystify while seated here. And clearly, if you look at that statement on the media, it was very clear. There were temperatures out here that we had already made a decision or we had an issue. And we simply had to clarify as the board that the process is on course, and we have given the client a fair hearing, which we will do. No decision was passed in terms of whether the clerk is being dismissed or is being disciplined in any other way. Thank you. And on the documents that you say, the evidence that you are not supplied with, you have said it here, not in that letter, because that letter was not meant for us. But since you have noted it here, every evidence as we handle accusation per accusation, we'll be giving you the evidence for your records.
Just to revert, you have talked about a fair hearing, and I'm grateful that you're willing to give my client that. It is a process, it is not an outcome. So kindly, if you're able to supply us so that you're able to prepare in lieu of that fair hearing, yeah, because they're in your custody, we are also, entitled to have a look at them so that we're able to respond appropriately.
Thank you. And I would want to make it clear, Wakili, with all due respect, we are saying that we'll handle this matter by matter. As we handle matter by matter, we'll be servicing you with the evidence. The evidence is against the response that he gave. So we have to go step by step. All the other evidences that need to be filed for your use later, maybe in a court of law, to challenge any decision that may come up. Because we are not here to make a ruling. We are here to give a fair hearing. From there, the board shall sit and communicate further. If you feel you'll be dissatisfied with the communication of the board, whether positive or negative, it is allowed to be challenged in court. And from there, we shall have our lawyer, you shall have your lawyer, and we shall be meeting in the other processes. So I would like to just say that we have to proceed, and we give you we'll be servicing you per item because we read the response. We give you per item the evidences. What we know, if we start giving you these files, we will go case by case, we give you the evidence, you keep it for your records, and we'll allow you to be the custody of those evidences.
I will be opposed to that. My client is as well. Yeah, I believe your counsel can advise you as well. There's something called, I know this is not a court process, but there's something called pre-trial. Your wakili can advise you as much, I believe. It is only appropriate that your suppliers, so that we save on time as well.
Okay, then I think the other option is I can give you a copy of this file so that when we'll be going together, I refer you to a letter. That is part of the evidence. Because are you trying to imply that we should not do before we give you the evidence? We can give you the evidence, we go together, we go along with it together as we are seated here.
Kindly suppliers so that we're able to prepare for trial.
How much time are you talking about?
Depending on the bulk of the documents, I'll be able to assess the time.
Okay, I would also want to bring to your attention that it is not the fault of this board that you didn't communicate to be provided with those evidences early. It is now you are giving us a notice, and therefore it will also be unfair to say that we want to give you the evidences as we are doing the sitting, then you request for time. We can give you the evidences are not complex, they are just proofs of the accusations. And remember, this is not a prosecution process that we have to judge and jail someone or do something. We are here to do a fair hearing. So any other process that is judicial completely then requires that moving forward. Because now you are putting us in quagmire in a way, I can say, because this letter was never serviced to us early so that we could say, have your evidences as here. So even if we were to give you a file here, we will only be referring you to the letters or to whatever that is supposed to be referred to, so that from there you can now make your other conclusions with.
I believe this is a hearing that you rely upon the Constitution to conduct. You're guided by the law. You are advised, my client here, to come with counsel for reason. You have counsel as well to advise you as much. I believe there's no urgency in handling this matter. You don't have to complete it today. Which is why, now that you have rejected the letter to you dated the 1st of July, in fact you have said you've scrapped it off, you have scrapped our letter off, we have requested that you supply us today so that you're able to prepare. We can take another hearing. There is no urgency in handling.
Wakili, with all due respect, this is a house of record, and the assembly has the powers of a high court. You know that. We have a timeline to give feedback to this assembly. So we cannot be postponing our fair hearing, yet we have everything that is here. Unless, as we'll be analyzing the evidence, we will want to know if there is anything that requires more of the time from what we have.
I believe there's not been an adjournment before in this matter.
Yes?
We have not had an adjournment before in this matter, have we?
We have not?
Had an adjournment before in this matter. This is the first hearing.
Yes.
Which is why we are requesting again from the suppliers with the documents before we can proceed.
And Wakili, we gave the notice to our client days away ago. You only serviced a letter on 1st, which was how many days back? Just 2 days back. It is just a day before yesterday. So if you yourselves had a timeline, why couldn't we, after the client got this letter of appearance, notice of appearance, you could have gotten that instruction earlier. So it's now that you want to request more time. In your letter, you'd have done to request for more time, we would have agreed. But since you appeared here today, and you wrote a letter to Kiambu County, then NYAMIRA County could not respond.
Chair, with your kind permission again, and with all due respect to your position right now, the letter is addressed to the chairman of this board. Let us not do a back and forth on this issue.
Let me read it.
We have the documents or we don't.
Let me read it.
That is the issue.
Let me read it. Dear sir, it is to the chair, but to which chair?
Of this board.
Kiambu County Assembly. The clerk belongs to Kiambu County Assembly. So we could not respond on a clerk that belongs to the Kiambu County Assembly. On the headline, yes, it is addressed to our chair. We received it. And the reference is disciplinary hearing. We don't know if the Kiambu County Assembly has a clerk that is called Daniel Orina.
Was it received under protest, Mr. Chair? Was the letter received under protest? It was not.
Under
I
protest,
believe your counsel can guide you on service of documents. The same was served to this official email of your county chairman. Kindly service us with documents so that we are able to respond. That is all that I'm requesting.
I think we are doing back and forth, which is a bit taking of time. We are servicing you with documents, not regarding this letter. It's because you have requested here. Because the best we could do, even if it was served in our email, we redirect this letter to the clerk of Kiambu County Assembly. Now that you have requested, we are servicing you the documents, but we are giving you an hour to look into it. That is the ruling of the chair. So that we can now agree after an hour. Exactly 1 hour. It's 11:34, so at 12:35, we reassemble and we now look into the matter together. You can wait in the office of the clerk.